Good morning. This is going to be a lesson on comparative public law, which means that I will be talking obviously about public law and not private law, and it will be in a comparative perspective, which means talking about different legal systems in the context of public law. But before I start talking about the lesson that I'll be giving this morning, I'd like to underline the fact that obviously when we talk about law, something that I always underline to my students is, and this is paraphrasing a famous song of a few years ago, that law is all around us. Everything that we do is related to law. The fact that I'm giving this lesson right now is part of my contract with the university that I work for, but I'm also at the same time, so this would be part of what we would call labor law, but at the same time I'm also expressing my freedom of expression, but also my freedom to teach in a certain way. Nobody's told me how to teach this lesson, and this is part of those rights and freedoms that are often contained in what we would call a codified constitution. And there are lots of other things that we could underline that are all to do with law, and that is why even for students not only studying law but also economics, it is very important to study these subjects. As I said, what I will be talking about in particular is comparative public law. When we do comparative law, to cite an important comparative lawyer of the early 20th century, Gutteridge, we can talk about descriptive comparative law, in other words, describing how certain legal systems work around the world. Or we can talk about applied comparative law, in other words, looking at particular aspects of a legal system and trying to see whether these can be applied elsewhere. In other words, there is a way of trying to use comparative law as a way of importing or exporting certain legal institutes. In the context of a course of comparative public law, one of the first lessons that students would have to attend is a lesson on what we would call forms of state and forms of government. Now already these two expressions are the result of comparative law. In other words, they are two expressions that derive from Italian scholarship and the expressions forma di Stato e forma di governo. These expressions are now used a lot even in the Anglo-American legal system, especially by those that specialize in comparative law. But what do these two terms exactly mean? Well, on one hand, when we talk about the form of state, we're talking about the relationship between the state, in other words, constitutional bodies, and on the other hand, citizens. Whereas if we talk about the form of government, we're talking about the relationship between constitutional bodies. Put in a different way, if we're talking about the form of state, we're looking at one hand those that govern us, and on the other hand those that are governed. Or another way of defining it, to take an expression used by famous Italian constitutionalist Costantino Mortati, we could talk about the relationship between authority and liberty.
Bocconi Virtual College, enrolling the smartest high school students.